You are listening to HOA Karen Patrol. I wish this was exaggerated. I am standing in the visitor lot at the Commons at Maplewood Ridge Association in Bangor, Maine, and Gloria Parker is waving a clipboard in my face like it is a warrant. She is screaming that I missed my hearing, that the board already voted, and that I owe $2,000 in fines plus legal fees. I tell her I was out of town on the date she is citing. She taps her smartwatch like it is a gavel and says I should have sent a proxy. I pull out my phone and show her the airline confirmation. The hearing notice she mailed was dated for a day I was in Boston for union training. She does not even blink. She just says the notice was valid and my absence counts as a waiver. That is when I realize this is not a mistake. This is a setup. And it is not the first time she has done this. I work as a union electrician apprentice, and my job site start times are strict. I cannot afford to miss custody hearings or visitation windows because of HOA games. Gloria Parker is the vendor coordinator for the association, which means she controls the tow company, the landscapers, the security patrols, and the compliance inspections. She has been running this place like a fiefdom for 3 years. Tonight, she is holding a stack of printed violations and a tow authorization slip with my unit number on it. She says my truck has been parked in a guest spot for more than 48 hours, and that counts as abandonment. I parked there yesterday afternoon. It has been less than 30 hours. She shrugs and says the timer started when she first noticed it, not when I parked. She tells me the tow truck is already on the way and that I can dispute it at the next board meeting in 6 weeks. Then she says her line. You do not get an opinion. You get a fine schedule. I stay calm. I ask her to show me the written notice that was supposed to precede any tow. She flips through her clipboard and pulls out a yellow sheet with today's date and a timestamp from this morning. I know I did not get a notice this morning. I was at the job site before sunrise and I did not come home until 20 minutes ago. She says the notice was placed on my windshield at 7 in the morning and that I must have lost it. I tell her I have a dash cam that records motion events. Her expression changes. She taps her watch again and says she needs to make a call. She walks 10 feet away, and I hear her on the phone with someone, saying that the owner is being combative and that she needs a deputy for standby. I do not move. I just take photos of her clipboard from a distance, and I start recording audio on my phone. The tow truck pulls into the lot 2 minutes later. The driver gets out and looks at Gloria, then at me, then back at Gloria. He asks her if this is the vehicle. She says yes and hands him the authorization slip. He looks at the slip, looks at my truck, and then asks me how long I have been parked here. I tell him less than 30 hours, and I show him the dashcam timestamp from when I pulled in yesterday. He shakes his head and tells Gloria he is not towing a vehicle that is under the notice window. She raises her voice and says the association has a contract and that he has to comply. He tells her he is not risking a lawsuit over a bad faith tow. He gets back in his truck and leaves. Gloria turns to me and her face is red. She says I just cost the association money and that she is adding a harassment complaint to my file. I ask her what file. She does not answer. She just says I will find out at the next hearing, and that this time I better show up. I go inside and I call the management company. The rep I reach sounds tired. She tells me Gloria handles all compliance enforcement and that the board trusts her process. I ask about the hearing I supposedly missed. She puts me on hold. When she comes back, she says the hearing was scheduled for 3 weeks ago and that I was notified by certified mail. I tell her I was out of state that day and I have proof. She says I should have responded to the notice or requested a continuance. I ask her to email me a copy of the notice and the certified mail receipt. She hesitates, then says she will check with Gloria and get back to me. I tell her I am requesting all records related to my unit under the association's records policy. She says there is a processing fee and a 10-day window. I tell her I will pay it. She hangs up. I sit on my couch and I stare at the ceiling. Something about this whole thing feels wrong. The dates do not line up. The tow was too fast, and Gloria acted like she was reading from a script she has used before. I open the neighborhood portal on my laptop. The Commons at Maplewood Ridge portal is a nightmare. It is full of screenshots, accusations, and multi-page threads where people argue about trash cans and holiday lights. I scroll back through the violation threads, and I see a pattern. There are at least 6 complaints from different owners over the past 2 years that all sound the same. Missed hearings, backdated notices, fines that appeared after the fact. Every single one of them mentions Gloria. One post from a year ago says the owner received a hearing notice for a date that had already passed. Another says they paid a fine, and the payment was marked as late, even though they submitted it on time. A third owner says Gloria threatened to tow their car during a compliance inspection and then filed a harassment complaint when they objected. The thread is locked. The account that posted it is deleted. I screenshot everything I can find. The next morning, I get an email from the management company. It has 2 attachments. The first is a scanned copy of the hearing notice. The notice is dated 3 weeks ago, and it lists a hearing date that matches the day I was in Boston. The second attachment is a certified mail receipt with my address and a tracking number. I plug the tracking number into the Postal Service website. The record shows the item was delivered, but the delivery date is 2 days after the hearing. I screenshot that too. I forward the whole chain to my buddy Derek, who sits on the Architectural Review Committee. He calls me 10 minutes later and says he has heard rumors about Gloria, but nobody wants to go on the record because she controls the vendor contracts, and she has allies on the board. He tells me there was an incident 2 years ago involving a landscaping company that refused to work with her. She got them banned from the property, and the board backed her up. He says, if I am going to fight this, I need to be ready for her to escalate. I spend the weekend digging. I file a formal records request with the association for all meeting minutes, violation notices, and tow authorizations from the past 3 years. I also request the vendor contract files and any correspondence related to compliance enforcement. The management company emails back and says the request is overly broad and that I need to narrow it to specific documents. I reply and list every category again, one by one. They send me a payment link for $250. I pay it. They say the records will be ready in 10 business days. I set a calendar reminder. On Monday morning, I get a letter in my mailbox. It is from Gloria. It is not on association letterhead. It is printed on plain white paper with a clip art logo at the top. The letter says, I am in violation of the guest parking policy and that my truck must be moved to my assigned space within 24 hours, or it will be towed without further notice. I checked the policy handbook. Guest parking is allowed for up to 72 hours for residents who have guests or who need temporary overflow space. My truck has been in my assigned space since Saturday. I take a photo of the letter and I email it to the management company with a timestamp photo of my truck in my assigned space. No response. If this sounds insane, hit the like button and subscribe, because it gets worse. That same afternoon, a man in a polo shirt with a contractor logo knocks on my door. He says he is here to verify compliance with an exterior maintenance notice. I tell him I never received an exterior maintenance notice. He pulls out a printed work order with my address and says it was issued last week. The work order says my patio furniture is in violation of the aesthetic standards and must be removed or replaced with approved furniture within 48 hours. I ask him who issued the work order. He says Gloria Parker. I ask him if he works for the association. He says no. He works for a vendor that the association contracts with for enforcement verification. I ask him what enforcement verification means. He says he is supposed to take photos and file a report. I tell him I am not letting him take photos without seeing the original notice. He shrugs and says that is my choice, but the report will note that I refuse to cooperate. I close the door. 10 minutes later, I get a text from a number I do not recognize. The text says I just failed a compliance inspection and that the board will be notified. I block the number. Derek calls me that night. He says he heard from another committee member that Gloria is talking about me at every board meeting. She is saying I am a problem resident who harasses vendors and ignores notices. Derek says the board president is starting to believe her because she brings binders and printed evidence to every meeting. He tells me I need to get ahead of this. I tell him I already filed a records request. He says that is good, but I need to be ready for her to bury the request or deliver incomplete records. He asks if I have ever looked at the meeting minutes from 2 years ago when the old treasurer resigned. I tell him no. He says I should. He says there was a vote to approve a new vendor contract, and the minutes were amended after the meeting. He does not know what was changed, but he remembers people arguing about it on the portal before the thread got deleted. I go back to the portal, and I search for archived threads. Most of them are gone. The site has a policy that threads older than 18 months get purged, unless they are pinned by a moderator. I try a public records request with the city to see if the association filed any of the disputed minutes with the county. The clerk tells me HOAs are private entities, and their minutes are not public records unless there is a court order. I thank her, and I hang up. Then I remember something. The association used to email a monthly newsletter with a summary of board actions. I search my old emails. I find 3 newsletters from 2 years ago. One of them mentions the vendor contract vote. The summary says the motion passed 4-1 with 1 abstention. I check the official meeting minutes that are posted on the portal. The minutes say the motion passed unanimously. That is not the same vote. I screenshot both. On Wednesday, I get a notice taped to my door. It is another fabricated violation. This one says my vehicle registration expired and that unregistered vehicles are not allowed on the property. I check my registration. It is valid until next year. The notice includes a photo of my truck. The photo is zoomed in on the license plate, but the angle is wrong and the plate number is partially obscured. I take my own photo of my plate with the current registration sticker clearly visible. I email both photos to the management company, and I ask who authorized the notice. No response. That night, Derek texts me and says the board is holding an emergency executive session tomorrow, and that my name is on the agenda. He does not know what they are planning, but he says Gloria requested the session, and she told the board president it is about a safety issue. I text back and ask if I can attend. He says executive sessions are closed and that I will not know what was discussed until they decide to tell me. I spend that night reviewing everything I have collected so far, the tracking number mismatch on the certified mail, the altered meeting minutes, the fabricated notices, the vendor showing up without a valid work order, the unauthorized tow attempt. Every single piece points back to Gloria. She is not just moving goalposts. She is creating a paper trail that does not match reality, and she is using her vendor access to intimidate people into backing down. I start to wonder how many other people have gone through this and just paid the fines because fighting it was too expensive or too exhausting. I think about the deleted portal threads and the locked accounts. I think about the tow driver who refused to take my truck and the contractor who wanted to file a report without evidence. And then I think about the hearing notice with the impossible date. That was not a mistake. That was a test. She wanted to see if I would catch it. And when I did, she escalated. The next day, I get a call from the management company. The rep tells me the board met last night and they voted to suspend my access to the common areas pending a full compliance review. I ask what that means. She says I cannot use the mailroom, the pool, the gym, or the parking lot guest spaces until the review is complete. I ask when the review will be complete. She says it depends on how quickly I provide the requested documentation. I ask what documentation. She says Gloria will send me a list. I tell her this is retaliation. She says it is a standard enforcement procedure and that I can appeal the decision at the next board meeting. I ask when the next board meeting is. She says it is in 5 weeks. I hang up. 10 minutes later, I get an email from Gloria. The email has a subject line that says Compliance Review Documentation Required. The body of the email lists 15 items, including proof of insurance, vehicle registration, lease or deed, utility account statements, and a signed acknowledgement of the community rules. I already submitted most of these documents when I moved in. I reply and attach copies of everything. She replies 1 minute later and says the copies are not acceptable and that I need to provide original certified documents. I do not respond. I call an attorney. The attorney I reach specializes in HOA disputes. I explain the situation. She listens and then asks if I have documentation of everything Gloria has done. I tell her I have screenshots, emails, photos, and recorded audio. She says that is good. She asks if I have proof that the hearing notice was backdated. I tell her I have the postal tracking record. She says that is very good. She asks if I am willing to go to mediation or if I want to sue. I tell her I just want this to stop and I want the fines reversed. She says mediation is faster and cheaper, but it only works if the HOA agrees to participate. She tells me to send her everything I have, and she will draft a demand letter. I ask how much it will cost. She says her retainer is $1,500. I tell her I will think about it. She says not to wait too long because the HOA will keep piling on fines until I either pay or move out. I thank her, and I hang up. Then I sit in my truck, and I stare at the steering wheel. I cannot afford $1,500 right now. But I also cannot afford to keep fighting this alone. That weekend, I get the records response from the management company. It is a PDF with 43 pages. Most of the pages are blank or redacted. The meeting minutes are included, but half of the entries are listed as executive session with no details. The vendor contracts are completely redacted except for the signature page. The tow authorizations are missing. The compliance notices are included, but only the ones that were officially logged in the system. None of the fabricated notices I received are in the file. I email the management company and I tell them the response is incomplete. They reply and say that executive session minutes are confidential and that vendor contracts contain proprietary information that cannot be disclosed. I reply and cite the state statute that requires HOAs to disclose enforcement records to homeowners. They do not respond. I forward the whole exchange to Derek. He calls me and says this is exactly what he expected. He tells me Gloria controls the records retention process and that she has been known to lose documents that make her look bad. He says the only way to get the real records is to subpoena them or to find someone who kept their own copies. I start reaching out to people on the portal who posted complaints about Gloria. Most of them do not respond. One person replies and says they moved out because it was not worth the fight. Another person says they paid the fines and signed a release just to make it stop. A third person agrees to talk to me on the phone. Her name is Lisa. She tells me she went through the exact same thing 18 months ago. She got a hearing notice for a violation she did not commit. The notice was dated for a meeting that conflicted with her work schedule. She called the management company and requested a continuance. They told her continuances are only granted for medical emergencies. She missed the hearing. The board voted to fine her $1,200. She appealed. Gloria showed up at the appeal hearing with a binder full of printed photos and time-stamped logs. Lisa says the photos were real, but the timestamps were wrong. She tried to explain that, but the board said Gloria's records were official and that Lisa's testimony was not credible. Lisa paid the fine. Then she got another notice 2 weeks later for a different violation. She paid that one too. She tells me Gloria has a system. She picks a target, she manufactures a violation, she escalates until the target either pays or leaves, and then she moves on to the next person. Lisa says she kept copies of everything. She emails me a zip file with 30 pages of documents. I open the zip file and I start reading. The documents include hearing notices, fines, emails, and photos. One of the hearing notices is dated for a Saturday. The association bylaws say hearings can only be held on weekdays. Another notice has a signature line for the board president, but the signature does not match the president's signature on other documents. A third notice includes a photo of Lisa's patio with a trash can visible in the frame. The notice says the trash can was left out past collection hours. Lisa's notes say the photo was taken on a Sunday morning, but trash collection is on Thursday. The timestamp on the photo file shows it was created 3 days after the alleged violation. I compare the documents to the ones I have. The format is identical. The language is identical. Even the clip art logo is the same. Gloria is using a template. And she is filling in the dates and details after the fact. I spend the next 2 days building a timeline. I map out every violation notice, every hearing, every fine, every appeal, and every vendor interaction. I include Lisa's case, the cases from the portal threads, and my own case. The pattern is clear. Gloria targets people who are new to the community or who do not attend board meetings. She issues a violation notice with a short deadline. If the person complies, she issues another notice with a different requirement. If the person pushes back, she escalates to a hearing with a bad date or a short notice window. If the person misses the hearing, she gets a default judgment. If the person shows up, she brings a binder full of evidence that may or may not be accurate, and the board sides with her because she is the one who manages the vendors and keeps the property running. The system works because most people do not have the time or money to fight it. And the ones who do fight eventually give up because the process is designed to be exhausting. I also noticed something else. Every single case involves a vendor interaction, either a tow truck, a contractor, a landscaper, or a security patrol. Gloria is not just enforcing the rules. She is using the vendors to create pressure and to generate documentation. The vendors do not care if the enforcement is legitimate. They just care about getting paid. And Gloria is the one who approves their invoices. I pull up the vendor contract pages from the record's response. The signature page lists 3 companies. One is the tow company that tried to take my truck. One is the contractor who showed up at my door. The third is a property management consulting firm that is not listed anywhere else in the documents. I searched the company name online. The business address is a mailbox rental in a strip mall 20 miles away. The website is a single page with stock photos and generic service descriptions. The domain was registered 2 years ago. I run the business name through the state registry. The company is registered to an LLC. The LLC manager is listed as G. Parker. I screenshot everything. Then I sit back and I stare at the screen. Gloria is not just abusing her role as vendor coordinator. She is running a side business that profits from the enforcement actions she initiates. Every time she orders a tow, her company gets a cut. Every time she sends a contractor to verify compliance, her company gets paid. Every time she processes a violation, she is creating billable work for herself. And the association is paying for it. I checked the budget summary that was posted on the portal last year. The line item for vendor services increased by 40% over 2 years. The line item for compliance enforcement doubled. The board approved the budget without question because Gloria told them it was necessary to maintain property values. I forward everything to Derek. He calls me 5 minutes later and says this is bigger than he thought. He tells me I need to go to the state. I look up the state agency that regulates HOAs. The website lists a complaint process for homeowners who believe their association is violating the law. I download the form. It asks for a description of the violation, supporting documents, and a statement of harm. I fill it out. I attach the timeline, the vendor contract pages, the business registry screenshot, the altered meeting minutes, the hearing notice with the bad tracking number, and Lisa's documents. I mail it certified with return receipt. Then I email a copy to the management company and to the board president. I include a cover letter that says I am requesting mediation and that I expect a response within 10 days. The board president replies 2 hours later. His email says the board takes all complaints seriously and that they will review my submission at the next meeting. He does not mention mediation. He does not mention Gloria. He does not mention the vendor contract. I reply and ask if Gloria will recuse herself from the review since she is named in the complaint. He does not respond. The next day, I get a notice in my mailbox. It is from the management company. The notice says the board has scheduled a special hearing to address my compliance status and that I am required to attend. The hearing is set for tomorrow at 10 in the morning. I check my work schedule. I am supposed to be at the job site at 6. If I leave at 9:30, I will miss half a day. If I do not attend, Gloria will get another default judgment. I text my foreman and explain the situation. He tells me to handle it and to bring documentation for the missed hours. I thank him. Then I call Derek and ask if he can attend the hearing as a witness. He says he will try, but he has a conference call at 10. I tell him it is fine. I have been recording everything anyway. He tells me to be careful and to stay calm no matter what Gloria says. I tell him I have been calm this whole time. He laughs and says that is probably what is driving her crazy. I show up at the clubhouse at 9:50. The board president is sitting at a folding table with 2 other board members. Gloria is sitting off to the side with her rolling file cart. She has a laptop open and a stack of binders in front of her. The board president asks me to sit. He says the purpose of the hearing is to review my compliance status and to determine whether the suspension of common area access should be continued. I ask if I can record the hearing. He looks at Gloria. She says recordings are not allowed because the hearing involves confidential homeowner information. I tell her everything she is about to say is already in the public record because I filed a state complaint. Her face hardens. The board president clears his throat and says we can proceed without a recording. I pull out my phone and I place it face down on the table. I do not turn it off. I press record before I set it down. Gloria stands up and she opens the first binder. She says I have violated the guest parking policy, the vehicle registration policy, the exterior maintenance standards, and the compliance review process. She says I have refused to provide requested documentation. I have harassed vendors, and I have made defamatory statements about association staff on the community portal. I interrupt and ask her to show me where I posted anything on the portal. She flips to a printed screenshot. The screenshot shows a post with my name on it. The post says Gloria Parker is corrupt and should be removed from the board. I tell her I never wrote that post. I pull out my laptop and I log into the portal. I show the board president my account activity. The last post I made was 6 months ago, and it was about a pothole in the parking lot. I tell him someone is using my name to fabricate evidence. Gloria says the screenshot is from the administrative backend and that it shows the original post before it was deleted. I ask her to show me the metadata. She closes the binder and says the metadata is not relevant. The board president tells her to move on. She opens the second binder. This one has photos of my truck in the guest parking lot. The photos are time-stamped. She says the photos prove I was parked in the guest lot for more than 72 hours in violation of the policy. I pull out my dash cam footage and I show the timestamp from when I parked. The dash cam shows I parked at 4:15 in the afternoon. Gloria's photos are stamped at 7 in the morning, 2 days earlier. I tell the board president the photos are from a different day and a different vehicle. I zoom in on the license plate in her photos. The plate number is wrong. It is not my truck. Gloria's face goes red. She says the photos were taken by the security patrol and that the timestamps are generated automatically by the camera system. I ask her to provide the original image files with the embedded metadata. She says the files are stored on a vendor server and that she does not have access. I tell the board president I can provide my dashcam files right now if he wants to compare them. He looks at Gloria. She closes the binder and says we can move on. She opens the third binder. This one has copies of the hearing notice and the certified mail receipt. She says I was properly notified and that my absence from the hearing was voluntary. I pull out the postal tracking printout. I show the board president the delivery date. The delivery date is 2 days after the hearing. Gloria says the tracking record must be wrong because the receipt shows it was delivered. I ask her to explain how I could have received the notice after the hearing and still been expected to attend. She does not answer. She just says the notice was valid and that I had other ways to find out about the hearing, including the posted agenda on the portal. I pull up the portal on my laptop. I show the board president the meeting calendar. The hearing was never posted. Gloria says it was an emergency hearing and that emergency hearings do not require advance posting. I ask her to cite the bylaw that allows emergency hearings. She taps her smartwatch and says the board has discretion to hold hearings as needed. The board president interrupts and says we are getting off track. He asks me what I want. I take a breath. I tell him I want the fines reversed. I want the suspension lifted. I want an apology. And I want Gloria removed from any role that involves enforcement or vendor coordination. He looks at Gloria. She stands up and she slams her binder shut. She says I am trying to undermine the association and that everything she has done is within her authority. She says the board gave her the authority to enforce the rules and that she is just doing her job. She says if I do not like the rules, I can move. Then she says it again. You do not get an opinion, you get a fine schedule. I smile. I pull out my phone and I play the audio recording from the night she tried to tow my truck. Her voice comes through the speaker. You do not get an opinion, you get a fine schedule. The board president stares at her. I stop the playback. I tell him I have recordings of every interaction. I have emails. I have screenshots. I have vendor contracts. I have business registry records. And I have a state complaint that is already under review. I tell him Gloria is not just enforcing the rules. She is profiting from enforcement actions through a side business that she controls. I slide a printed copy of the business registry across the table. The board president picks it up. He reads it. He looks at Gloria. She does not say anything. She just picks up her binders and she walks out. The board president calls a recess. I sit in the parking lot for 20 minutes. Derek texts me and asks how it went. I tell him I will explain later. The board president comes outside and asks me to come back in. I follow him inside. Gloria is not there. He tells me the board is going to refer the matter to an outside mediator and that they will suspend all enforcement actions against me pending the outcome. He says the mediation will include a neutral third party and that both sides will have an opportunity to present evidence. He asks if I am willing to participate. I tell him yes. He says he will send me the mediator's contact information within 48 hours. I thank him. I leave. I sit in my truck and I call Derek. I tell him what happened. He says Gloria just made a huge mistake by walking out. He says the board cannot ignore this anymore. He says I won. I tell him it is not over yet. I still have to get through mediation. And I still have to deal with whatever Gloria is planning next. 2 days later, I get an email from the mediator. Her name is Susan. She is a retired judge who specializes in HOA disputes. She says the mediation is scheduled for next Thursday at 2 p.m. at the sheriff's substation lobby. She says both parties are required to bring all relevant documents and to be prepared to discuss a resolution. She says the mediation is confidential and that anything said during the session cannot be used in court unless both parties agree. I reply and confirm. Then I spend the next week organizing everything I have. I print copies of the timeline, the vendor contracts, the business registry, the hearing notice, the postal tracking record, the altered meeting minutes, the fabricated violations, Lisa's documents, and the audio recordings. I put everything in a binder with tabs. I label each section. I make a second copy for the mediator. I rehearse what I am going to say. I do not want to sound angry or petty. I just want to present the facts and let the evidence speak for itself. On Wednesday night, I get a call from an unknown number. I answer. It is Gloria. She says she wants to talk. I tell her anything she wants to say should be said at mediation. She says she is calling as a courtesy to let me know that she is going to file a defamation lawsuit against me for making false statements to the board and to the state agency. She says I accused her of fraud and corruption without evidence, and that she has been damaged professionally. I tell her I have evidence, and that I submitted it to the state. She says the state has not contacted her, and that my complaint is frivolous. I tell her the state does not move fast, and that she will hear from them eventually. She raises her voice. She says I do not know who I am dealing with, and that she has been doing this for years. She says she has outlasted every other person who tried to challenge her, and that I will be no different. Then she says her boomerang line. Go ahead and call whoever you want. I have a committee for that. I do not respond. I just hang up, and I smile, because she just gave me one more recording. The next day, I show up at the sheriff's substation 30 minutes early. Susan is already there. She is sitting at a table in the lobby with a notepad and a laptop. She introduces herself and asks me to sit. She says Gloria called her this morning and said she might be late because of a vendor meeting. I tell Susan that is fine. I pull out my binder and I hand her the second copy. She flips through it. She asks a few clarifying questions. I answer them. She tells me she reviewed the state complaint and that she spoke with the agency investigator yesterday. She says the investigator confirmed that my complaint is under active review and that the agency is planning to interview board members and vendors within the next 2 weeks. She says that puts pressure on the HOA to resolve this quickly. She asks me what I want out of mediation. I tell her I want the fines reversed, the suspension lifted, a written apology, and a policy change that prevents this from happening to anyone else. She writes it down. Then she asks what I am willing to accept if the HOA refuses. I tell her I am willing to accept a settlement that includes a refund of all fines, a guarantee that no further enforcement actions will be taken against me, and Gloria's removal from any role involving compliance or vendors. She nods. She says that is reasonable. Gloria arrives 15 minutes late. She is carrying her rolling file cart, and she has a man with her. The man introduces himself as the board president. Susan asks them to sit. Gloria sets her cart beside the table, and she pulls out 3 binders. Susan tells her to summarize her position. Gloria says I have been a problem resident since I moved in, and that I have repeatedly violated community rules despite multiple warnings. She says I have harassed vendors, defied board authority, and made false accusations in an effort to avoid accountability. She says the fines are valid and that the suspension is appropriate. Susan asks her if she has documentation to support that. Gloria opens the first binder and starts pulling out papers. Susan holds up her hand and says she does not need to see the papers right now. She asks Gloria if she is aware of the state complaint. Gloria says yes. Susan asks her if she is aware that the complaint includes allegations of fraud and self-dealing. Gloria says the allegations are false. Susan asks her if she can explain the business registry record that shows she owns a vendor consulting firm that contracts with the association. Gloria does not answer. The board president clears his throat and says he was not aware of that until the hearing. Susan looks at me. She asks if I have anything to add. I slide the printed business registry across the table. I slide the vendor contract signature page next to it. I slide the budget summary next to that. I tell her Gloria has been using her role as vendor coordinator to funnel association money to her own company. I tell her the vendor invoices increased by 40% over 2 years and that none of the board members questioned it because Gloria told them it was necessary. I tell her Gloria has been manufacturing violations to create billable work for her vendors, and every time she does that, her company gets paid. I tell her I have documentation of at least 6 other homeowners who went through the same pattern of escalating violations and fabricated evidence. I tell her Gloria is not enforcing the rules. She is running a protection racket. The board president's face goes pale. He looks at Gloria. She stands up. She says this is a witch hunt and that I am trying to destroy her reputation. She says she has done nothing wrong and that every action she took was authorized by the board. Susan tells her to sit down. Gloria does not sit down. She grabs the handle of her file cart and she starts to walk out. Susan raises her voice and tells her if she leaves now, the mediation is over and the state complaint will proceed without any input from her. Gloria stops. She turns around. Her face is red and her hands are shaking. She sits down. Susan takes a breath. She tells both sides that she is going to recommend a resolution. She says the association will reverse all fines and fees assessed against me. The association will lift the suspension immediately. The association will issue a written acknowledgement that the enforcement actions were not supported by valid evidence. Gloria will resign from her role as vendor coordinator effective immediately. The association will terminate the contract with Gloria's consulting firm and will conduct an audit of all vendor payments over the past 3 years. The association will adopt a new policy that requires independent review of all enforcement actions and prohibits board members or staff from having financial interests in vendor contracts. Susan looks at me and asks if I accept. I tell her yes. Susan looks at Gloria and asks if she accepts. Gloria does not say anything. The board president looks at her and then looks at Susan. He says the board will accept on behalf of the association. Susan says that is not enough. She needs Gloria to accept personally. Gloria stands up again. She says she is not accepting anything and that she is going to fight this. She says she has a committee for that. I pull out my phone. I play the recording from last night. Her voice fills the room. Go ahead and call whoever you want. I have a committee for that. Susan stares at her. The board president stares at her. The deputy at the front desk looks over. Gloria grabs her cart and she walks out. The wheels squeak on the tile floor. The door slams behind her. Susan looks at the board president. She asks if the board is willing to proceed without Gloria's consent. He says yes. Susan says she will draft a settlement agreement and send it to both parties by the end of the week. She says the agreement will be binding once it is signed by the board president and by me. She says if Gloria refuses to comply, the association can remove her through a board vote or through legal action. The board president nods. He thanks Susan. He looks at me and says he is sorry. He says he did not know what Gloria was doing and that he should have paid more attention. I tell him it is not his fault, but that the board needs to do better going forward. He says he will. He shakes my hand. He leaves. I sit with Susan for a few more minutes. She tells me this is one of the more blatant cases she has seen, and that the state agency will probably impose fines on the association. She says I should be prepared for Gloria to retaliate in some way, but that the settlement agreement will give me legal protection. She tells me to keep copies of everything and to report any further contact from Gloria to the sheriff. I thank her. I leave. I drive home and I sit in my truck for a long time. I do not feel victorious. I just feel tired. I think about Lisa and the other people who paid the fines and moved on because they did not have the time or the resources to fight. I think about how many others there might be who never posted on the portal or who deleted their accounts after Gloria threatened them. I think about how long this went on and how many people enabled it by not asking questions. And I think about the fact that it took a state complaint and a mediation session and a recording of Gloria incriminating herself before anyone took it seriously. I pull out my phone and I text Derek. I tell him it is over. He texts back and asks if I won. I tell him the association agreed to reverse the fines and to remove Gloria from vendor coordination. He texts back a thumbs up emoji and says he is proud of me. I thank him. Then I go inside and I pour a drink and I sit on my couch and I do not think about anything for a while. The settlement agreement arrives 3 days later. It is 4 pages. It lists all the terms Susan outlined at mediation. The association agrees to reverse all fines and fees. The association agrees to lift the suspension. The association agrees to issue a written acknowledgement. Gloria agrees to resign from vendor coordination. The association agrees to terminate the consulting contract. The association agrees to conduct an audit. The association agrees to adopt a new policy. I read it twice. I sign it. I scan it and email it back. The board president signs it the same day. Susan emails me a fully executed copy. She says the settlement is now binding and that I can enforce it through the courts if the association fails to comply. I print a copy and I put it in my binder. Then I email a copy to Lisa and to the other people who shared their stories with me. I tell them what happened. I tell them they can use the new policy to challenge any old violations if they want to. Most of them do not respond. One person replies and says thank you. Another person says they wish they had fought harder. I do not know what to say to that. I just tell them, it is not too late. 2 weeks later, I get a letter from the state agency. The letter says they completed their investigation and that they found evidence of multiple violations of state HOA statutes. The letter says the association failed to maintain accurate records, failed to provide proper notice of hearings, and failed to disclose conflicts of interest involving vendor contracts. The letter says the association is required to pay a penalty of $5,000 and to implement corrective measures within 90 days. The letter says Gloria Parker is prohibited from serving in any fiduciary role with any HOA in the state for 5 years. The letter says the agency will conduct a follow-up review in 6 months to ensure compliance. I read the letter 3 times. Then, I take a photo of it and I post it on the neighborhood portal with a short caption. The caption says, the system works if you document everything, and if you do not give up. The post gets 43 likes and 12 comments. Most of the comments are supportive. One comment says, I should run for the board. I do not reply to that one. A month later, the association holds its annual meeting. I attend. The clubhouse is packed. The board president opens the meeting and he reads a prepared statement. He says the board takes full responsibility for the failures and oversight that allowed improper enforcement actions to occur. He says the board has adopted a new policy that bans surprise inspections and requires written notice and a cure checklist for all violations. He says the board has hired a new management company and that all vendor contracts are being reviewed. He says Gloria Parker is no longer affiliated with the association in any capacity. He says the association is committed to transparency and accountability going forward. There is scattered applause. Then he opens the floor for questions. A woman in the back raises her hand and asks what happens to the people who already paid fines that were not valid. The board president looks at the new management company rep. The rep says anyone who believes they were improperly fined can submit a refund request with supporting documentation. The woman asks if there is a deadline. The rep says no. The woman sits down. Another person raises their hand and asks if the board will publish the audit results. The board president says yes, the audit will be posted on the portal once it is complete. The meeting continues for another hour. I do not speak. I just listen. At the end, the board president thanks everyone for attending. People start to leave. Derek walks over and asks how I am doing. I tell him I am fine. He tells me I did a good thing. I tell him, I just wanted it to stop. He nods. He says a lot of people are grateful, even if they do not say it out loud. I thank him. I leave. I walk back to my unit, and I see a couple sitting on their porch. They are watching me like it is a show. The woman raises her coffee mug in a small salute. The man nods. I nod back. I go inside and I close the door. I sit on my couch and I think about everything that happened. I think about the fabricated notices and the altered minutes and the bad faith tow attempt. I think about the mediation table and the look on Gloria's face when I played the recording. I think about the state letter and the new policy and the annual meeting. And I think about the fact that it worked. Not because I was lucky, not because someone felt sorry for me, but because I documented everything, and I used the system the way it was supposed to be used. I walked away on purpose, because I wanted her to follow and say more. And she did, and I caught her. And now it is over. The next week, I get an email from Lisa. She says she submitted a refund request and the association approved it. She says she got back $800. She thanks me. She says she never thought it would happen. I reply and tell her I am glad it worked out. She asks if I am going to run for the board. I tell her no. I tell her I just want to live here without drama. She says she understands. She says if I ever need anything, I should let her know. I thank her. I close the email. I look at the calendar. It has been 2 months since the night Gloria tried to tow my truck. 2 months since I started digging into the records. 2 months since I realized this was not just about me. And now it is done. The fines are reversed. The policy is changed. Gloria is gone. The association is paying attention. And I can finally stop checking my mailbox every day for another fabricated notice. I pour another drink. I sit on my couch. I do not think about HOAs or enforcement or vendor contracts or mediation. I just sit. And for the first time in 2 months, I feel like I can breathe. Thanks for watching, and I will catch you in the next one.